So I am going to appoint Donna Chaffins as our official court reporter for this proceeding. And this is the arraignment in the Ashland County Common Pleas Court of Howard Dwayne Walters. Mr. Walters, how are you today? Excuse me?
I'm well.
Good to hear that. So this is Common Pleas Court case number 23 CRI 188, and Mr. Walters is here with Mr. Mayor. So, Mr. Mayor, we are here for an arraignment.
Yes, ma'am.
And everyone was made aware that that is what we're doing today. The state of Ohio is represented by Mr. Tinnell and Mr. Callow from the Ashland County Prosecutor's Office. So, Mr. Walters, have you actually physically received a copy of the indictment against you?
Yes, ma'am.
And Mr. Mayor, if you could fill out some of the details of that while I make sure that this chair is not going to run away with me.
Yes, ma'am. Your Honor, I can acknowledge receipt of the indictment on my client's behalf. He was served, I believe, on July 21st, 2023. We're going to waive any defects in service. We're also going to waive reading of the indictment at this point in time. I have had the opportunity to sit with my client at the jail both on July 23rd and also here this morning, and we discussed the indictment in detail. I answered questions for him, and I feel comfortable waiving reading of the indictment. We would ask you to allow us to enter a general plea of not guilty as to the indictment and set the matter for further proceedings, and I am prepared to speak on bond at the appropriate time.
Okay.
I would also like to mention, Judge, that I am entering today for arraignment purposes only. By way of background on this case, I was retained by Mr. Walters on January 30th, 2023, and was retained on a pre-indictment status, so to speak, during the perhaps so-called investigative portion of this case. It is my belief and expectation, at least my hope, that I will be entering my appearance formally going forward to represent him to the conclusion of the case. But I am asking the court for a bit of time here as the family has the opportunity to gather resources and hopefully get me retained officially going forward. Thank you.
Thank you. So going back to this indictment, Mr. Walters, I trust everything your counsel just said to me, but so I understand that you've actually read this indictment for yourself. I
Yes.
need out louds.
Yes.
Okay, thank you. And you understand what it is they say you did wrong?
Yes.
And so we'll show that you are going to waive, I understand, the reading of the indictment. You don't need me to read it to you.
No, ma'am.
Okay, we will be, as requested, entering a plea of not guilty in your behalf. So on the matter, certainly the court appreciates Mr. Mayor being here for the purposes of arraignment, serving as counsel for Mr. Walters. And just for the record, the court did discuss Rule 5.04 of the Ohio Supreme Court's rules of appointing counsel in capital cases, so that may be of interest. Anything on behalf of the state of Ohio?
Only, Your Honor, given the limited appearance of Attorney Mayer, would the court agree that the speedy trial time would be told until such time as counsel is settled as to the defendant?
I think that I cannot, without thinking that through, grant that right now. I didn't hear Mr. Mayer request anything other than a bit of patience while necessary arrangements are made to settle the issue of counsel. So I don't think that I'm in a position to say that that would constitute a tolling of the speedy trial time just for that purpose. On the other hand, there may be other motions the gentleman will be filing that would toll the speedy trial time. I take it, Mr. Mayor, you are going to continue to make yourself available to Mr. Walters while he is in county jail in this case?
Absolutely, Judge.
Okay.
I will.
And then you wanted to discuss bond?
I would like to, yes. May I be heard?
Yes, certainly.
Thank you. My client is 58 years old. As I understand it, he presents with absolutely no prior criminal history. He has what amounts to excellent ties to the Ashland County area. He is a resident and has been since 2003. He also has strong family ties, is married, and his children, at least one of his daughters, lives here. He has maintained consistent contact with me. He has been aware of this investigation since its inception at the end of January 2023. I was retained after his detention, and like I said, he has been in consistent communication. If there's been any need to meet with me or have a phone conversation, he's one of the most cooperative and responsive clients I have on my caseload. That said, Your Honor, my understanding, as the state has indicated, and what's brought us here, is that the indictment was issued on July 21st. It was issued with an arrest warrant, as you can imagine, and it didn't take much doing for them to locate my client. He was arrested that very same day at his residence, where you would expect him to be without incident. And so, despite the seriousness of these charges, obviously, we believe that given his strong ties, lack of record, and awareness of this investigation, yet the fact he's made himself available for indictment service and arrest, we do not believe he poses a flight risk. And so we understand bond to currently be set at $3 million following the bond setting, I believe, what amounts to a week ago. We would ask the court to consider setting a lower cash bond, or perhaps a component that would be a bail bond, which is, I believe, what they refer to as an appearance bond in other places, and give my client a better opportunity to perhaps posting something. I believe he will make his court appearances. Thank you.
On behalf of the state of Ohio.
Thank you, Your Honor. Your Honor, the state alleges, and we understand that these are allegations at this time, that the defendant, in a premeditated manner, and in this particular instance, very premeditated, executed his son-in-law. So when counsel says they understand the seriousness of the charges, these are the most serious charges that one can face. The reasonableness of the bond, however, $3 million seems like a big number right out of the gate. However, if one considers that the bondsman is generally at about 10% in order to post and work that out that way, we're talking $300,000. This defendant is the owner of at least 10, we think 11 various real estate properties that would total well in excess of that amount. He has the resources. Those are just properties that he owns. That's not cash and assets and other things on the side. So given this defendant's circumstances, we don't believe that the bond is unreasonable as currently set. Thank you.
Thank you. Well, what the court would really appreciate doing, considering my lack of knowledge about the surrounding circumstances that bear on bond, and your Mr. Walters' circumstances that also influence bond, is if you could spell that all out in a brief but effective motion. The state of Ohio can respond to it promptly. This being a capital case, the defendant has no constitutional right to a bond. Classically, bond, I think, should be set. And one has been set, and I noticed that it was set at $3 million, but it was still accompanied by a whole host of conditions about not leaving the county, the state, being subject to GPS monitoring and things like that. So there's certainly within reason that a lower bond with all of those extra side conditions could be considered, but I'd like to not be making that decision here today with such an early involvement in the case. For example, the magistrate who set bond in this case a week ago still placed the defendant subject to a curfew for 24 hours a day, 7 days a week. And as well as the GPS monitoring. So there may be some room to lower the bond, and given all of the detailed orders that can be used to accomplish the purposes of a bond. But rather than make a decision today, we'll wait for more information. Is there any objection from either party to the circumstances under which the court conducted the bond hearing? Any difficulty there?
What was the question, Judge?
Whether there was any objection to or difficulties with how the court conducted the bond hearing?
No, not at this time.
Okay. On behalf of the state?
No, ma'am.
Okay. So we will show that Mr. Walters has been arraigned on these charges. Bond will be continued as of today. And we need to set a time for a first pretrial. Hopeful that we will have the matter of counsel, if at all possible, put to rest before then, but if not, we'll deal with it again at that time. So have counsel arrived at some possible pretrial dates and times that would work on your calendar?
I have my calendar in front of me, Judge. Any that are suggested I can take a look at right now.
Why don't we go off the record and we can do that.
How much time?
A couple weeks, 3 weeks. Is that going to be comfortable for you as far as the other issue?
So somewhere the week of the 14th?
I think so. Maybe could we look at the week of the 21st?
That week is very open with the exception of the 24th.
Take a look. I could do the afternoon of the 22nd. Afternoon of the 22nd, Judge?
Yes, in the neighborhood of 3 or 3:30.
I think
That's fine.
3 o'clock looks great.
Excuse me?
3 o'clock looks fine, or 3:30, whichever works better.
Okay. So let's return to the record. After consulting counsel, the court will set the first pretrial in this matter for August 22nd, which is a Tuesday. Am I right, gentlemen?
Yes,
Yes,
ma'am.
At 3:30 p.m. This will be conducted on the record with an official court reporter, but it will be by Zoom technology, I believe, unless I hear an objection to that.
No objection from the state.
No objection, and I'll make arrangements to be out at the jail with my client.
Yeah, that would be the court's condition, is that Mr. Walters should be accompanied by counsel at that proceeding. Anything further on behalf of the state of Ohio?
No, ma'am. Thank you.
On behalf of the defendant, Mr. Mayor?
No, Your Honor.
Okay, so Mr. Walters, any difficulties, any confusions? Are they feeding you out in the jail?
Yes, ma'am.
Okay, so and you arrangements have been made, your family to visit, you're receiving necessary medicines and things like that?
Yes, ma'am.
Good to hear. Well, this concludes our proceedings. Thank you all.
Thank you.
Thank you, Your Honor.